Good evening, Madam Chairwoman and committee members. Thank you for the opportunity to testify. My name is Jennifer Fleck. I'm a parent and an attorney. I am for HB 3135. I have provided the relevant code sections and highlighted the changes that HB 3135 provides. And I also provided sample jury charges that display how these defenses work against children and favor the offender. First, I'd like to address the repeal of the defenses in Texas Penal Code 4324. As we all know, as American citizens, we enjoy the First Amendment right to free speech with few exceptions. Obscenity is one of those exceptions and is not constitutionally protected speech. In order to find a defendant guilty of obscenity to a minor, every juror must agree that the defendant knew for certain that the material was harmful, as defined by the Miller test, and directed it to a child anyway. Although knowing harm should be enough to sustain a guilty verdict, Texas law allows an additional layer of protection for offenders. A defendant found guilty of obscenity to a child may be excused for an education, scientific, governmental, or other similar justification, which is other similar is not defined in the code. If the jury finds that it's more likely than not that there is justification for the harm, then the jury must return a not guilty verdict. Exposing children to legally harmful materials under the guise of education, science, and art appreciation denies Texas children constitutional protection. There are 7 states that do not have these defenses today. Texas should join these states and be leading in the protection of children. Second, I'd like to address the repeal of the defenses in the Texas Penal Code 4325. In 4325, it's an offense to solicit a child for sexual conduct or sexual performance that includes sexual conduct. Again, Texas law provides an additional layer of defense for certain offenders. A defendant found guilty of soliciting a child for sex could assert an educational, medical, psychological, psychiatric, judicial, or legislative purpose. If the jury finds that it's more likely than not that there's a bona fide purpose for the solicitation, then the jury must return a not guilty verdict. The sad truth is that a successful defense as to obscenity or solicitation doesn't mediate or lessen the harm. The child or the family is no less harmed when the guilty are free from consequences and accountability. It's bad law and based on bad science and allows for unsafe environments. These defenses reflect a conscious disregard for the health of children. For these reasons, we ask that you immediately consider taking a vote on HB 3135 and send it to the local and consent calendars.
Okay. Madam Chair.
Yes. Chair King?
Thank you. I'm probably going to regret asking this. Well, first, how long has these defenses been statutory?
Okay, so
this long.
I have the history that I didn't include in your packet, but on 4324, the defenses have been in the code since the model penal code was
like
adopted.
1975, something like that.
And so the Miller test was, the Supreme Court adopted the Miller test in 1973, and these defenses have been in the code prior to the Miller test, and then these defenses were never taken out of our code.
So I hate to ask this, but can you give me a couple examples where these have been used, these defenses? I'm having trouble envisioning, particularly the legislative.
So I went to the library in the Capitol and tried to research how these defenses originally got in. What I can tell you about 4324 is they were adopted from the model penal code, and that's why a lot of the states have these same defenses.
Can you give me a couple fact situations where they've been used? I'm just
curious. Representative Kane mentioned it, but you may not have caught it. So there was a recent case in Texas, an appellate in Texas. I actually talked to the mother on the phone, and the abuser, one of his defenses was that the pictures, the sexual pictures that he was sending to the child were to cheer her up because she was depressed and suicidal. So I know that sounds ridiculous, and in court you would say, no jury is going to believe that defense. My comment to that is that, however, because the defense is allowed in the code, the family and the child still has to hear the person put on the testimony. So it's lengthening the trial. It's adding confusion to the jury. Now the jury has to consider an affirmative defense, even if it's not credible.
Got it.
It shouldn't be there.
Got it. Yeah, I just
just shouldn't be there.
This has been a night for bizarre facts and circumstances.
I have really enjoyed, actually, the committee meeting tonight. Sorry. I'm a weird one, probably. It is late, though.
Does anyone else have any questions for Ms. Fleck? All right, thank